Hello, I'm Natasha Karamichou, and in the next two podcasts, we will continue exploring parental benefit and donation laws and rules in Greece. As you very well know, it is common in our country for the younger members of the family to receive financial support, either in the form of cash benefits or through the transfer of movable or immovable assets through parental benefits. What does a parental benefit consist of? It can be a transfer of full ownership of the movable or immovable property whereby the parent ceases to have any authority and all rights to them and they are transferred to the child. This benefit can be in the form of money, bonds, shares, real estate, private vehicles, or anything else that can be classified as property. It also includes transfer of full ownership to the child and retention of the usufruct by the parent to ensure his or her security. This means that the parent, as usufructuary, can use the thing to meet his or her needs or otherwise reap the benefits of the thing, such as by entering into a lease agreement and collecting the rent. If one of the parents owns the property, he or she can retain the usufruct for himself, herself, and for his or her spouse after the death of the first one, donation in death, through the same contract. The parent cannot, however, transfer the property. On the other hand, the child acquires the ownership, but this ownership lacks the above mentioned powers, which are now held and exercised only by the usufructuary. How is parental benefit established? A parental benefit is established by a contract, a notarial deed, between the parent and the child, and in this case, the child is obliged to nothing in return. Moreover, the parental benefit cannot be established unilaterally or by will. What is the tax for a parental benefit? Under the provisions of the 2021 law, the tax-free amount of donations and parental benefits of assets and cash has been increased to €800,000 for the beneficiaries, as for example spouses, persons who have entered into a civil partnership, children, grandchildren, and parents. The old tax scale applies to donations between the other beneficiaries categories and third parties, and the same applies to inheritances. After the law amendment, monetary parental benefits and donations up to the amount of €800,000 between the aforementioned relatives will be tax-free. The increase in the tax-free amount of the donation parental benefit from 150,000 to 800,000 euros has prompted more citizens to transfer their property. Thus today, the parental benefit tax is zero for property up to 800,000 euros. If the amount is higher, the parental benefit tax is lower than in the past. In particular, donations and benefits above 800,000 euros are taxed at a rate of 10% of the value of the asset after deduction of the aforementioned amount. What is the procedure for a parental benefit? A lawyer, acting on behalf of the transferor, should check the correctness and legality of the title deeds, the existence of any mortgages or seizures, the content and terms of the contract to be drawn up, and collect the necessary documents required for this purpose. Indicatively, proof of tax and insurance information of the transferor, certificate from the municipality where the property belongs, which shows that no real estate tax (TAP) is due, certificate of land property or land extract of the National Land Registry, certificate of engineer for arbitrary constructions, building identity, energy performance certificate, ENFIA house tax certificate for the last 5 years. After the submission of the necessary documents, the notary public will draft the text of the contract, which includes the description and acquisition history of the property, the special conditions, and finally the acceptance from the part of the child. The public notary will also post the parental benefit tax return on the fiscal authority's website. The process is completed with the signing of the contract by the parties and the registration of the deed at the relevant land registry. Can we revoke the parental benefit? Parental benefits can be revoked under specific conditions and certain procedures that must be followed. Usually, cancellation is only possible in cases of serious reasons, such as recipient's ingratitude or defects in the donor's will when the contract was drawn up. For example, if the child has shown improper behavior towards a parent, such as gross antisocial behavior, violation of moral standards, or neglect him or her when the parent is in need, On the other hand, the same stands if at the time of the transfer the parent lacked the necessary mental capacity or his/her will was impaired due to mental disorders or deception. The cancellation procedure is a court procedure. The donor must file a petition for revocation at the appropriate court, providing specific evidence of the cause for revocation, such as court orders or documents providing the recipient's ingratitude. Revocation will be made if the court finds that the conditions are met. Revoking, however, a parental benefit is a serious procedure and a specific legal route is to be followed.